The tort concept of causation has long been a stumbling block for law students and legal practitioners alike. In June v. Union Carbide Corporation, the Tenth Circuit wrestled with the question of how a plaintiff must establish causation if multiple potential causes exist. For almost 50 years, Union Carbide Corporation and Umetco Minerals Corporation ran a mining operation that produced millions of pounds of uranium oxide. The companies founded a town in Colorado named Uravan to house their employees. In 1986, due to radiation emissions produced from the mining operation, the Environmental Protection Agency identified Uravan as a hazardous site, and the residents were evacuated. A group of former residents who had been diagnosed with cancer or thyroid disease sued the companies for negligence. The companies argued that the former residents had failed to prove that they wouldn't have sustained injuries but for the radiation emissions. However, the former residents argued that Colorado law required them to prove only that the emissions were one of the substantial contributors that caused their injuries, even if the injuries could have been caused by other factors absent the emissions. The district court disagreed and held that Colorado law required the former residents to prove the emissions were both a but-for cause and a substantial factor in causing the injuries. Therefore, because the former residents failed to prove but-for causation, the district court granted summary judgment in the company's favor. The former residents appealed.